Yes.
I was dealing with the appropriate test. We've summarised our position on this in the speaking note at 2.2. So if I could take you to that. And I've made the point that the Divisional Court, in fact, applied the most generous test of manifestly without reasonable foundation, paragraphs 46 to 47, so that there can be no quarrel about that. But in fact, if any of my learned friends' criticisms were valid, we in fact say that the court would have been fully justified, and this court would be justified in approaching it from the point of view of a more exacting test. One can see in SC, which my learned friend took you to, that there is a basis there for what's called a flexible approach that depends on the subject matter and the importance of what's at stake. And one can see, if I can take the court to page 568 of SC at paragraph 157, under the heading Conclusions on the Manifestly Without Reasonable Foundation Approach. There, if we go to paragraph 158, Lord Reid says, nevertheless, is appropriate the approach which this court has adopted since Humphreys, that's manifestly without reasonable foundation, should be modified in order to reflect the nuanced nature of the judgment which is required, following the jurisprudence of the European Court. In the light of that jurisprudence, as it currently stands, it remains the position that a low intensity of review is generally appropriate, other things being equal, in cases concerned with judgments of social and economic policy in the field of welfare benefits and pensions, so that the judgment of the executive or legislature will generally be respected unless it is manifestly without reasonable foundation. And then this, nevertheless, the intensity of the court's scrutiny can be influenced by a wide range of factors, depending on the circumstance of the particular case, as indeed it would be if the court were applying the domestic test of reasonableness. In particular, very weighty reasons will usually have to be shown, and the intensity of review will usually be correspondingly high if a difference in treatment on a suspect ground is to be justified. Those grounds as currently recognised are discussed in paragraphs 101 to 113 above. But as I have explained, they may develop over time as the approach of the European Court evolves. But other factors can sometimes lower the intensity of review even where a suspect ground is an issue. Equally, even where there is no suspect ground, so that's our case, there may be factors which call for a stricter standard of review than might otherwise be necessary, such as the impact of a measure on the best interests of children. Here we have someone sentenced on the basis of his status of a child at the time.
Can you just help me on what is meant by suspect ground?
That's race, religion, nationality, or political. That's one of the key factors.
So it doesn't apply here.
Race or gender, no. It is therefore important to avoid a mechanical approach to these matters based simply on the categorisation of the ground of the difference in treatment. A more flexible approach will give appropriate respect to the assessment of democratically accountable institutions, but will also take appropriate account of such factors as may be relevant. And then it cites the case of Godin Mendoza, which had to do with discrimination against same-sex couples. The court should generally be very slow to intervene in areas of social and economic policy, such as housing and social security. But as a general rule, differential treatment on grounds such as sex or race nevertheless requires cogent justification. It may also be helpful to observe that the phrase manifestly without reasonable foundation, as used by the European Court, is merely a way of describing a wide margin of appreciation. A wide margin has also been recognised by the European Court in numerous other areas where that phrase has not been used, such as national security, penal policy, and matters raising sensitive moral or ethical issues. It follows that in domestic cases, rather than trying to arrive at a precise definition of the ambit of the manifestly without reasonable foundation formulation, it is more fruitful to focus on the question whether a wide margin of judgment is appropriate in the light of the circumstance of the case. The ordinary approach to proportionality gives appropriate weight to the judgment of the primary decision maker, degree of weight which will normally be substantial in fields such as economic and social policy, national security, penal policy, and matters raising sensitive moral or ethical issues. that's really the passage I need to refer the court to. Can I just make...
Or does penal policy cover that? Does it cover this?
No, my lord, in my respectful submission, can I just make this submission on that? It's right that there's a reference there to wide margin of appreciation in areas of penal policy. So, my lord, in our respectful submission, if one was dealing with the other part of the Act which increased the penal terms for HMP detainees, that's to say about the appropriate general quantum of punishment, that would be an area of penal policy. Equally, and this is reflected in a case called Akbar, which you have at tab 13 of the authorities, page 498, paragraph 73. They were talking about prison management being an area of wide margin of appreciation, where it's a matter of prison management. But it's one thing to say that Parliament should be accorded deference in such areas. It's another to say the court cannot adopt careful and close scrutiny here, because we have to look at what's at issue here. We're dealing with a case where the question of arbitrariness is an issue, where it conceded that this is discrimination in an area within the ambit of Article 5, and where there is a retrospective denial of a minimum term review. That was the right and expectation of all those sentenced to this historic and unique sentence. And you've seen a sentence created as long ago as 1908 with a long history of saying that guarantees a review.
On what basis is that not for penal policy?
Well, my lady, it's not the kind of penal policy that is being referred to there, because it's a very specific a specific injustice to particular individuals, a retrospectivity. That's to say, those who, like this applicant, had for many years expected a review, are then denied a review. That's an area dealing where Clift, which I'll come to, talks about the risk of arbitrariness, we're dealing with something which is plainly, in our respectful submission, arbitrary and discriminatory to a small group whose rights are affected by the denial.
Is it not in pursuit of a particular penal policy?
Well, my lady, it's not said to do that. It's said to be minimising distress rather than having an overall penal policy. I mean, one can see a penal elsewhere in this statute where they say that we're going to increase the tariffs for HMP detainees. One can see that's an area of broad penal policy.
What about equivalence? Is that something that's relevant here in relation to custody for life and?
Well, my lady.
I mean, it's just
yes.
It's an open question.
Yes. No. Well, my lady, the point is, and perhaps this is made better when we look at Clift.
Yes.
Where an issue of, as it were, arbitrariness arises, and it's admitted that this is an area where the Article 14 arises in an area covered by Article 5, then that is particularly important. But so, my lady, we say the issue of individual injustice caused by retrospectivity is the first reason why it should call for careful and anxious scrutiny, careful, close scrutiny. And, my lady, even in the case of Clift, which was a case about parole eligibility, because the risk, so an issue related to penal policy, the European Court in that case adopted what it described as careful or close scrutiny. And this is far more a powerful case of injustice than that involved in Clift in the United Kingdom. Can I take the court to the case of Clift? And that Clift is at tab 8. And you can see the issue that was raised in that case.
reported in a report series. It's much better to have a report series, as the practice direction says. So you've got a head note.
My lord, I regret that, but I gather that there wasn't one because in every other case
Yeah, if there's no report, then there's no report. Yeah.
No, my lord, I'm very well aware of your lordship's
Adherence to the practice direction.
adherence. Yeah, luckily the facts are very helpfully encapsulated in one paragraph, and that's at paragraph 8, page 328. There you can see, under the legislation in force at the time, the final decision on early release in cases involving prisoners serving a determinate sentence of more than 15 years lay with the Secretary of State. For prisoners serving a term of less than 15 years, and for prisoners serving indeterminate, i.e. life sentences, the approval of the Secretary of State following a positive recommendation of the parole board was not required. So the parole board's decision was final. That, I think they're talking about discretionary life as there. On the 25th of October 2002, the Secretary of State rejected the recommendation of the parole board in the applicant's case, concluding that the release of the applicant would present an unacceptable risk to the public as a result that the applicant was not released. So the question was it unjustly discriminatory to accord to those other two groups the right to be released on the recommendation of the parole board, but in the case of those with over 15 years, to say that the Secretary of State could veto the positive recommendation of the parole board. And my lady, if one goes from there to paragraph 62, and see, sorry, I should just take you to 60, page 343, because it says at the bottom, paragraph 60, it should be recalled in this regard, this is page 343, it should be recalled in this regard that the general purpose of Article 14 is to ensure that where a state provides for rights falling within the ambit of the Convention, which go beyond the minimum guarantees set out therein, those supplementary rights are applied fairly and consistently to all those within its jurisdiction, unless a difference of treatment is objectively justified. So even if you don't have a right to parole, nonetheless, if there is a parole is accorded, it must be dealt with in a manner that is not discriminatory. And then paragraph 62, the court has frequently emphasised the fundamental importance of the guarantees contained in Article 5 for securing the right of individuals in a democracy to be free from arbitrary detention, where an early release scheme applies differently to prisoners depending on the length of their sentence. There is a risk that unless the difference in treatment is objectively justified, it will run counter to the very purposes of Article 5, namely protect the individual from arbitrary detention. Accordingly, there is a need for careful scrutiny of differences of treatment. So we do strongly rely on that we are in the ambit of Article 5.
What is that saying though? That isn't saying the test to apply when you're looking at Article 14, is it?
It is, because it then goes on to say that there's a need for careful scrutiny of differences in treatment, and this is in the context of an Article 14 complaint.
But I thought that was to do with status, the first, which is not an issue here, not the test for objective justification.
Yes, but my lord, if one goes on from there, one can see that when one gets to paragraph 73, they then apply close scrutiny against that background. Can I just take the court to page 73, 347? A difference of treatment is discriminatory if it has no objective and reasonable justification. In other words, if it does not pursue a legitimate aim, or if there's not a reasonable relationship of proportionality. The contracting states enjoy a margin of appreciation in assessing whether and to what extent differences in otherwise similar situations justify a different treatment. The scope of this margin will vary according to the circumstances, the subject matter and the background. A wide margin is usually allowed to the state under the Convention when it comes to general measures of economic or social strategy, because of their direct knowledge of their society and its needs. The national authorities are in principle better placed. The court will generally respect the legislature's policy. And then it goes on, the court must nonetheless exercise close scrutiny where there is a complaint that domestic measures have resulted in detention which was arbitrary or unlawful. Now, it wasn't arbitrary and unlawful in the Article 5 sense because there was no right, there's no right to parole recognised by the Convention, but one is within the ambit of an area where personal liberty is.
I follow that, but can we just focus on each of those words and see where they get us in this case?
Well,
in terms of detention being arbitrary, either arbitrary or unlawful.
yes.
What
Well, my lady, the complaint that is made is that the removal from this claimant, as he originally was, of the right to review deprives him of the reducible sentence to which he was originally sentenced. And so it requires close scrutiny. And it deprives all those in a like place. Moreover, in the broader sense, we're in an area where those in his like position can say, I was given a sentence whose rationale included a review with a view to reduction of the penal term at the halfway point. To take that away from me raises an issue of arbitrariness, particularly when the ground is simply the date on which I was sentenced. So that's why we respectfully submit it calls for what we would respectfully call close scrutiny. And one can see that the ratio of the case, which in many ways was not as strong as this case, is at paragraph 77 to 78. However,
look at 76 as well, because 76 says you can have bright line distinctions, and that of itself isn't a problem. 77 and 78 was saying you can't say we're doing this on grounds of risk when there's no evidence that the Secretary of State was able to deal with risk.
yes,
So 76 is against you, and 77, 78 is for you. You've got to look at them all.
my lord, I'm grateful. Well, definitely, it says, might appear arbitrary, a bright line was necessary and justified, but then it goes on, however, any distinction, well, my lord, as I think my lord observed earlier, the question is, what's the basis of the bright line here? And the basis of the bright line, we say, is arbitrary. It's the date of sentencing. However, any distinction in treatment between applicant and either of the comparator groups discussed above would only be justified where it actually achieved the legitimate aim pursued. In the present case, the government have failed to demonstrate that the approval of the Secretary of State would address concerns regarding the perceived higher risk posed by certain prisoners upon release. So that's really, as it were, is the legitimate aim actually advanced in any rational way by the means adopted? As Lord Bingham observed in the House of Lords, by the time the Secretary of State rejected the Parole Board's recommendation the applicant be released, life prisoners had been brought within the definitive jurisdiction of the Parole Board. The differential treatment of prisoners serving 15 years or more, whose release continued to be dependent on the decision of the Secretary of State, had become an indefensible anomaly, as the assessment of the risk presented by any individual prisoner in the application of publicly promulgated criteria was a task which was at the relevant time recognised to have no political content, and one to which the Secretary of State could not and did not claim to bring any superior expertise. In the circumstances, the Court considers the early release scheme to which the applicant was subject, which entitled those serving long determinate sentence of less than 15 years, and those serving indeterminate to be released upon a positive recommendation of the Parole Board, but required those serving long-term determinate sentence of 15 years or more to secure in addition the approval of the Secretary of State, lacked objective justification. There has accordingly been a violation of Article 5 taken together with Article 14. So, my lady, our submission is that this is an area involving an allegation, and we say a well-founded one, of arbitrary detention, contrary to the purpose of the sentence, and there has been discrimination in that context. All the other prisoners sentenced to detention during Her Majesty's pleasure have the review that we respectfully submit is the concomitant of the rationale of the sentence. This small subgroup, defined by reference to the random factor of the date of sentence, are denied it. And that we respectfully submit calls for careful or close scrutiny. But in any event, the Divisional Court found that even if one applied the wider test, the low test, there was in fact no objective justification, no reasonable relationship of proportionality either. My lady, my lords, can I now take you to the white paper, which is of course in September 2020. You have that in the supplementary bundle, 200 page. You have supplementary bundle. It's summarised in the Divisional Court's judgment, but perhaps I should take you to it at page 198 of the supplementary bundle. My learned friend took you to it this morning, but can I just take you to the key paragraphs again? And it says, offenders sentenced to DHMP may apply to the High Court for a review of the length of their tariffs at the halfway point. The purpose of this review is to determine whether the tariff should be reduced, and for a review to be successful, the child must show exceptional progress in custody. If the application is unsuccessful, the child can continue to apply every subsequent 2 years until the tariff expiry date. The existence of reviews is an important part of ensuring the tariff remains appropriate. So, in other words, it's saying there is a value and an importance to that right as children change and develop as they mature. So it's recognising the importance of that right. It is also clear, however, that the existence of the review procedure, and they're talking about the procedure then existing, particularly the opportunity for continuing reviews after the halfway point, can be extremely distressing. So it's the review procedure with the emphasis being on the continuing reviews. Families are contacted every time an offender applies for review and are given the opportunity to provide a new victim personal statement, a process which in many cases causes them to relive the circumstance of the crime and feel as though they have to advocate again for justice for their loved ones. This difficult process is also unlikely to lead to any benefit for the offender, as subsequent reviews are rarely successful. So there's 3 times it talks about the continuing and repetitive reviews as the vice which needs to be dealt with. Continuing reviews, contacted every time a person applies for review, as subsequent reviews are rarely successful. And then it goes on. This is why, so, and you get more of the same because one talks at 331, there's continually revisiting the events, and at 330, there's a reference to subsequent reviews which are being removed. All this is a justification, if anything, for limiting the number of reviews, not removing reviews altogether. And the white paper, the very first sentence says it's an important part of ensuring the tariff remains appropriate. And if one then goes on to this 329, this is why we propose to reduce the number of reviews an offender is entitled to after they turn 18. Offenders who are given life sentence for murders committed over the age of 18, or those who commit murders as children but who are not sentenced until they are over, are not entitled to reviews. That's to be the new proposal. Well, the equivalence between those who are given life sentence for murders committed over the age of 18 and those who commit murders as children but who are not sentenced until they are over 18 is a false equivalence. My lady put that to my learned friend. An adult convicted as an adult of murder is in a totally different position, both legally and factually, from someone who is a child under 18 commits murder. But they're treated the same there, but who are not
treated the same in respect of reviews. And one of the arguments that my friend, that your friend puts, is that that's because the bulk of any improvement, if you like, is likely to be got by 18, and that'll be the same for the person who commits murder at 18 and is sentenced at 18, and the person who commits murder at 17 years and 9 months and is sentenced at 18. He says they've had, in effect, the bulk of the change that they're going through at the time that you come to sentence.
My lord, the answer we respectfully make to that is threefold. Firstly, there is evidence, and it was in Dr. Delmarge's, that in fact, the change between the ages of 18 and 25 is just as significant as that between the ages of 14 and 18, because the changes in consequential thinking and impulse control are just as significant during those years. That's the first point. The second point is what matters from the point of view of the rationale of the sentence is whether there is any significant maturation process ongoing. And if one looks on to paragraph 330, it looks as if the mistake being made here is, because you see it here, we propose a new fairer system that recognise that offenders who are sentenced to it but have since turned 18 in custody are now adults and have passed the age where significant development occurs. Now that claim that they've passed the age where significant development occurs is plainly incorrect. And I know the court would have seen there are decisions of the Court of Appeal Sentencing Division talking about the cliff age, saying it's simply incorrect that you cease to develop significantly at the age of 18 and on your 18th birthday. And that's what the Divisional Court drew attention to. So the idea that there's no significant development after the age of 18 is simply incorrect. The idea that your rate of development and maturation decelerates is controversial, but in any event, it's irrelevant. Because what needs to be justified is taking away the review altogether from a sentence which is based, as Lord Bingham explained, on the notion of continued maturation even beyond the age of 18. And so we respectfully submit that for all those reasons, this justification, the justification that no significant development occurs, is plainly wrong. As the Divisional Court pointed out, it's inconsistent with cases such as Clark and Peters. The claim that it decelerates is highly controversial, but we would respectfully submit irrelevant, because the important point is you do continue to develop. And my lady made the point that if you have someone who's 17 and therefore when they're sentenced and within the test, their maturation during the period from 20 to 25 and from 25 to 30 is obviously going to be the issue. They're not deprived of the review. So it is, with great respect to the Secretary of State, both irrelevant and inadequate as a justification. And on no view can it be described as a new fairer system. It's manifestly unfair to those who have been given the expectation, like this applicant, that they will get a review, and then at the last moment have had it snatched away from them. And yes, you have the Annex A, which you have at page 69 of the bundle, sets out the many cases where exceptional progress is made during the mid-20s, my lord. So one can see, and in fact, many of the cases involve people who got a reduction after they were sentenced at the age of 18. So if the court just looks at our skeleton, at Annex A, you'll see that there's a whole load of examples, but just to take the court quickly through them. Page 70, Graham Slavin, aged at sentence 18 years, so he would now be disqualified, reduction 2 years, and you can see the basis of that. Then there's Mr. Nanvakuma, 18 years, he would now be disqualified, 1 year reduction, development around the age of 24. One sees in the next case, you can see number 48, Mr. Essel, 19 years of age, so he would now be ruled out. 30 years at the date of the review, 8 months reduction. Mr. Matthias, 18 years at the time of the review, 29 years at the date of the, at the time of sentence, 29 years at the date of review, 1 year reduction. Over the page, Mr. Omaregi, 18 years at the time of sentence, so he would now be disqualified, and then 1 year reduction, and significant progress made between the ages of 23 and 25, and then the Johns case. And I think the court, and the divisional court also at paragraph 51 referred to the fact that there were 7 cases between the years, I think, 2015 and 2019, of people who were sentenced over 18 and were nonetheless qualified on grounds of exceptional progress. So this is the fact that you do mature is established by the case law, the case of Clark and the case of Peters in particular. It's recognised by the neurological expertise, and it's demonstrated by the actual practice of according reductions. So that's what's being taken away. And in this particular respondent's case, what's being taken away is the expectation over many years that he would get a review towards which he worked, and which he would expect to lead to a reduction. My lady, it's agreed that we can look at the white paper. It's clear if we look at the white paper, the justification of equalisation is, in our respectful submission, not a good one. The claim of no significant development is not a good one. The claim of all your significant maturation will have taken place, or that there will be all your speedy maturation will take place, is wrong. But in any event is irrelevant, because the important point is that your maturation will continue. And we've set out all those factors at paragraph 2.3, Romans 1, 2, 3, and 4, and we made the point that paragraph 330, the white paper states that those who have turned 18 have passed the age where significant development occurs. This fundament is inconsistent fundamentally with the principles of established neurological facts in sentencing cases such as Peters and Clark, and it's also contrary to the Secretary of State's own policy statement on the 7th of February 2022, which records that, and I quote, "It is now widely understood that a child's entry into adulthood is not a singular event at the age of 18, but rather it is a slow process of maturation lasting until the mid-20s, and in some cases longer." So we say that the justification put forward in the white paper, which are still relied on, have little force or cogency, and they provide no proper justification for the denial of the right to review for those sentenced after they reach their 18th birthday. My lady, there was reference to the Ministry of Justice memorandum in the court below, and your ladyship will find that at page 220 of the, I think it's in the supplementary bundle at page 220, and I can just take the court briefly to that. Just two passages I think I should show. Page 220, the Ministry of Justice memorandum, and one can see there that there's a reference at page 220 to the case that gave rise to this proposal, the case of Ellie Gould, paragraphs 18 and 19, and then the option A is at page 221. Do you agree to enshrine the tariff review process into legislation for the reasons outlined above? And then it states, while only a small minority of applications do successfully obtain a minimum term reduction, there is precedent for individuals sentenced over 18 having their minimum term reduced. And the court's now seen that in Annex A and in the judgment of the Divisional Court. And then they give a percentage at paragraph 29, which roughly works out at about 7. And then one sees at paragraph 30, a removal of the review will be seen to go against evidence on maturity continuing beyond the age 18. Increasing neuroscientific evidence demonstrates that young adults are still maturing up until the age of 25. There have been recent policy changes recognising a lack of maturity and continuing vulnerability beyond the age of 18. And then it makes the point about court delays, risk being a cause of an offender losing entitlement to a review. If age or point of sentence was the determining factor in whether an offender was eligible for a minimum term review, then court delays out of their control could mean that an offender becomes ineligible for a minimum term review if they turn 18 in the interim, which may be perceived as an unfair outcome. The HMP sentence, although technically separate to the tariff review entitlement, is clearly defined as unique for those who commit murder as a child. Given this, there is general support for the role of reviews as part of this. And one can see there's reference to a power to convert DHMP sentences to life. I'm not commending that power to the court, but obviously, but it exists.
What do you submit we should make of the MOJ memorandum in the context of the issues we have to decide?
Well, simply that there was a consideration given to the issue, and this may go to proportionality, my lady, of making exceptions. Can I just take you to that? And that was rejected on a misconception.
But where does it? I mean, what's the ultimate conclusion we should draw from this that is relevant to, and how would it feed into our decision we have to make? And I can see what the document says, but how does it fit in?
Yes. Well, my lady, there's reference to background materials by Lord Reid at that paragraph dealing with white papers. So it would come in under that general heading of background materials.
Can I get the chronology straight in the understanding? So this went to the Lord Chancellor. Was this before or after the white paper?
This is before, yes.
This is before
Yes.
the white paper, okay.
Yes. Okay. Well, could I just, my lady, so it's basically on the basis, how did this, what's the history of this legislation? How did it evolve? And what issues was it purporting to deal with? It's just one further passage I'd just like to show the court. It's in paragraph 42 at page 223. We propose exploring potential for an exception to the rule for individuals who turn 18 during the court process to mitigate for unfairness. If you, Lord, do wish to pursue it, are you content for us to explore the potential? The comment was, no, their youth is already factored into the sentencing process. The fact that they won't be entitled to review is a matter for the court to take into consideration. Well, that the court couldn't take that in because they wouldn't know whether they were going to succeed or not in their review. And that's a point that is made by the Divisional Court, that paragraph I'm so sorry. Yes, okay, I'm so sorry. My lord, we will check the date.
I think the memorandum is 16 October, the white paper is September.
So it came after.
It came after.
Oh, I'm so sorry. Yes, I'm so sorry. Thank you. Yes. So
When was the bill presented to Parliament? After the 16th of October.
yes. Well, we've got the Hansard, my lord, at the back. And
So by this time, it was clear that the mistake that was made, that they didn't have a review, must have been understood within the Ministry of Justice, otherwise they wouldn't be talking about this, would they? So the mistake that was made, the assumption in the white paper that people sentenced at 18 plus didn't have a review, that's obviously not the working hypothesis of this white paper, because they consider whether or not to have it. So that error had been corrected by the memorandum, and then must have been a different basis when the bill was introduced in Parliament.
yes, it was corrected so far as policy, but we'd say that the misunderstanding. I mean, my lord, all I can say is the burden is on the state, obviously, to justify. Every time the state has been called to justify this, they've produced the white paper, those 3 paragraphs, and said that is the justification to the court. And then they say, well, the court shouldn't be criticised, shouldn't be too exacting in looking at it. Well, what else are you supposed to do when the Article 14 requires the court to test whether there is, 1, a legitimate objective, and 2, it's proportionate. So you obviously have to look at the white paper, because that's what they put forward. They say, look at the white paper, that's our justification. And my lord, and when one comes to the question, did they use the least intrusive means, as it were? Did they, I mean, this person actually appeared in court before his 18th birthday for the first time in May and was sentenced. So he appears when he's still under 18 in court for the first time. So he is to that extent covered by this.
No, my concern is a different one.
Yes, I'm sorry.
We're actually reviewing an Act of Parliament, and since the government has to say, in practical terms, they bear the burden of proof because they're the party in court. But I was more concerned to make sure that Parliament hadn't operated on the last document before it was an incorrect white paper. And it looks as if the last document leading up to the introduction of the bill was the memorandum to the Lord Chancellor, and I assume the Lord Chancellor introduced the bill, but nobody's told us that.
Well, you've got, my lord, the Hansard, the only, which is the last bit in the puzzle. And my learned friend is right to say that there was an amendment introduced, but if I can just show the court the point made, and I think my lady actually put it to my learned friend, is if you look at the Undersecretary promoting the bill, one has the points being made by the opposition. I think there were 7 people in all participating in this discussion. 2 of them opposition, 5 for the government. But Mr. Philip, the Undersecretary, at page 312, and I think my learned friend's really dealt with this point already. He doesn't say anything about the removal of the right from those who are sentenced after their 18th birthday. As my own friend accepted, what he's dealing with is another issue, and that's exactly the point that the Divisional Court made, because they were being asked to look at this. There's nothing from the Minister on this issue. That's, say, the issue of the removal of the review, because what he deals with, if one looks at it, page 3112, these reviews provide an opportunity to look again at the minimum term handed down. It's important to remember that we are talking about a cohort of people who have committed a very serious offence. As the Shadow Minister said, when sentence is first passed on a child, the judge passing sentence will include in the consideration the maturity of the person at that point. There is an acceptance that further maturing may occur subsequently, which is why the review mechanism exists. Even with the reform proposed in clause 104, there can still be a single review once the individual is over 18. Well, not in the case of those who are to have the right removed. It's only subsequent reviews, a second, third or fourth review, that the clause would preclude. Given the likely length of sentence or of minimum terms, as well as the fact that most people receiving a first sentence will probably be in their mid or late, it's very likely that in almost all cases there will be one review after the age of 18. So there's nothing about, we are taking away a very important right retrospectively from those who are sentenced after 18, but we think it's justified. There's no reference, it's all about subsequent reviews. And then at the top of the next page, on the point about people maturing beyond the age of 18, the first sentences, that is reflected in the sentence passed by the judge, informed by pre-sentencing reports. As I've said previously, the law as we propose to amend it will still allow, most likely in almost every case, or very many cases, a single review after the age of 18. Apart from the elliptical reference to in almost every case, there's no reference to what they're doing in terms of taking away this right. And then it's all about multiple bites of the cherry and repeated reconsideration. You'll see multiple bites of the cherry next bit, and then repeated reconsideration every 2 years in the under 345. So, my lady and my lords, the white paper justifications which have been put forward as the justifications don't stand up. The justifications, no justification for this particular thing was put forward by the Minister to Parliament. All the emphasis, and perhaps this is the telling point, the emphasis was on the issue about subsequent continuing views, several bites of the cherry. That was the concern. And that's what he was talking about. So that is our respectful submission as to the inadequacy of the reasons that have been put forward. Now, my lady, if I can turn to part 3 at page 7, the relevance of Parliament's consideration. I claim that section 27A redefines or amends the sentence of DHMP. The Secretary of State's principal submission to the Divisional Court was that the sentence redefined or amended by the removal of the section of the right to review by section 27A11. But the finding of the Divisional Court at paragraph 47 was that section 27A did not change the nature of the sentence of DHMP. Indeed, if one looks at section 27A, it repeatedly refers to the sentence to detention during Her Majesty's pleasure and doesn't suggest that, as it were, it's being amended or changed. Just simply refers to the fact that there will be no review. Now, my lady, that may be unimportant, except for in relation to Article 7, how we resolve that debate. Because as my Lord, or Justice Lewis put to me, the important question is, as it well, where are we now? What is the position? Is this? Well, I think you should put it to my learned friend. Is the position we've got now discriminatory? But it cannot be a fair criticism of the Divisional Court that they simply said, to the point being argued by the Secretary of State, oh, the sentence has been redefined and amended. They simply said, well, there's no evidence that Parliament were intending to redefine or amend the sentence, as opposed to simply removing the review from a small subgroup. And so, my lady, that's really that's the point we make at 3.1. If you look at the relevant provisions, one sees, for example, at section 259, is still referring to page 57, section 259 of the Sentencing Act. There's still a sentence of detention during Her Majesty's pleasure, unqualified, unamended, and without any suggestion that it's been altered. But even if one looks at section 27A,
What about the section that says lump them together with other life sentences? Is that something that's important?
well, I think that's been done before.
324, life sentence means a sentence of detention for life. Page 81, or during Her Majesty's pleasure.
I think
You need to be equating the two as life sentences for semi-early release provisions.
yes, I think that was just, I think that had been done in relation to release regimes before.
I think they did in the 1990, but I haven't checked.
Yeah, I think your lordship's right. It's 1997 that they, for the purpose of the release regimes. But if you look at so pages 7 to 8, the amendment of 27A, there is a sentence of detention during Her Majesty's pleasure imposed on a person, application of a minimum review. And in subsection 8, in this section, DHMP means a sentence of detention during Her Majesty's pleasure imposed under a provision listed in column 1. And it's a perfectly reasonable point for the divisional court to make that the sentence itself and the idea that it's being changed or amended, which was my learned friend's point, it's been redefined, it's been amended. There's no evidence of that. The only thing that happens is at 11, subsection 11, there is no right of any person who serve it to request, and that conferred by this section. So by implication, those who are sentenced after 18 don't have that right. But obviously we say that that is very significant, and we make the point at 3.3, it was a big step to remove the crucial and defining element of the sentence of DHMP. That the divisional court made the point that it's to interpret section 27A as a change in the nature and ambit of would be inconsistent with Parliament's maintenance of the sentence of DHMP, which had a well-established rationale requiring an inherent right of review. And we submit that it would raise issues of retrospectivity. If there was any evidence that Parliament had addressed that issue of retrospectivity, then one would be more confident, well, Parliament had considered all the issues and resolved them. But in any event, and this is really the final point and the most important one, if one just looks at the current, this is at 3.4, if one looks at the current legislative regime, it clearly gives rise to an issue of discriminatory treatment, contrary to Article 14 and a justified complaint of arbitrariness. It retains the sentence for all those convicted of murder under the age of 18, but denies a small subgroup the essential safeguards associated with that sentence. I think my lady put to my learned friend will, as it were, is there a difference between custody for life and detention during Her Majesty's pleasure? That is the difference. That detention during Her Majesty's pleasure has a different history and rationale, but the difference now is if you get detention during Her Majesty's pleasure, you get a right to a reducible sentence. And that leads on to the submission of the need for careful scrutiny for objective justification. Now, my lady, we've dealt with the impact of the legislation at part 4, and we've dealt with it in great detail in the skeleton at 30 to 42. And I do just ask the court to refer to that fuller exposition of the impact in our skeleton. But what the appellant responds, and this is at 4.2 on page 8 of our submissions, is that it's entirely rational to deny a review on the basis of the defender's age at sentence, and then says the full panoply of protections for those who offend in childhood continue to apply. Well, you get no more rights than a discretionary life award or someone who's sentenced as an adult. And then they say, save the right to apply for a minimum term review. In that respect, placing the cohort in the same position as those sentenced to detention for life and or custody for life. Well, we answer that the respondent was never sentenced, nor could he have been sentenced to custody for life or detention for life. He was at all times subject to a distinctive and unique sentence, specially designed for those who committed murder whilst under 18 and therefore children-in-law. Secondly, he is denied the full panoply of protections for those convicted of murder as a child, because he's deprived of the most crucial right, the fact that it carries with the right to a review of the minimum term, for the reasons given by Lord Bingham and Smith. And then thirdly, we submit, it's contrary to fundamental principle to determine the substantive punishment to be imposed on the basis of the defendant's age at the date of sentencing rather than at the date of offending. My lady, we've set out the authorities for that, but Lord Bingham makes the point at paragraph 12. The determining factor is what was your age at the time you offended, and the divisional court deals with that in its judgment at paragraph 48. Can I just take the court to the judgment at paragraph 48? And at paragraph 48, the divisional court sets out the first limb of secondary justification is that at the age of 18 a person is an adult. This should be treated as a bright line for the purpose of sentence. This proposition is not sustainable. As we have set out in our review, principles of new sentence, the age of an offender at the date of conviction in almost all cases will determine the type of custodial sentence to be imposed. But the mere fact that a person has achieved their 18th birthday will not determine whether a custodial sentence should be imposed, and if so, of what length. What is critical is the age of the offender when the offence was committed. As explained in Ahmed, the culpability of the offender must be assessed by reference to age at the time of the offence.
Well, if one just stops there, the culpability of the offender is one of the issues to be looked at by the sentencing judge at the time. And is there any room for saying that there is a distinction between that issue and the one that is to be looked at prospectively, at any rate, or even retrospectively, during the course of a review, which is exceptional progress since you were in detention? Well,
my lady, I think the real point is that what Lord Bingham says is that paragraph 12 of Smith is, it is it's the lesser culpability of someone who offends under the age of 18 that calls for this particular sentence. That's the reason why you get the sentence, because they're less culpable. And then the consequence of getting that sentence because you're less culpable is that you get the review.
But you're leaving out of account entirely the change to the minimum term, and that Lord Bingham said he expressly wasn't dealing with the change to the minimum term. And you do now have sentencing of anyone, 18 or under 18, on the basis of the best assessment of culpability that you can get at the time. And when you have the review, the statutory factors appear to be looking not at a review of how guilty were you, should you have got 8 years or 10 years, they're looking at have you exceptionally made progress?
Well, my lord, can I just answer that in this way? Firstly, when section 82A introduced judicial tariffs of the section 82A of the 2000 Act, it said nothing about modifying or changing detention during Her Majesty's pleasure. It simply introduced tariffs. So, and it was not interpreted as having removed the reducibility of the sentence that was imposed. Indeed, that was the background against which people are sentenced. You're given this sentence. This is the maximum you can serve. But if you're under DHMP, you're entitled to a reduction, or entitled to seek a reduction. My lord, Lord Bingham envisaged two circumstances, and I agree that exceptional progress was the key one. The other one was where something comes out during the course of detention which suggests that a lesser period was actually appropriate. So he wasn't saying it was exclusively about progress. I agree that the main focus, and indeed the divisional court saw the main focus as exceptional progress. But my lord, that is the basis on which you get detention during Her Majesty's process, that you are, because you're less culpable, you're entitled to this more benign and rehabilitative sentence, although it's mandatory for all of them, and it carries with it certain corollaries. Until that sentence is, as it were, abolished, we respectfully submit that it carries with it that promise and that right. And indeed, the practice of the Home Secretary has always been, until this new legislation, that's right, and therefore there would be a review. So, my lord, that's the basis on which we put the argument that the divisional court were correct in their approach at paragraph 48. But in the end, again, the question is, can one justify the difference of treatment simply based on the date of sentence? At paragraph 49, the division court goes on. We remind ourselves, this is page 899, what was said at paragraph 329 of the white paper, that offenders who are given life sentence for murder committed over the age of 18, or those who commit murder as children, but who are not sentenced until they're 18, are not entitled to reviews, reflecting the fact that adults do not go through the same accelerated development. Well, you have our submissions that they were wrong to conflate offenders who committed offences over the age of 18 and those who committed murders as children. To seek to achieve equivalence between them was simply mistaken. And there was no recognition that this approach failed to reflect established sentencing practice. And then they go on to, at paragraph 50, what was said at paragraph 329 of the white paper also involved the proposition that someone aged 18 was an adult who would not be subject to the same accelerated development as a child. And they make the point, which we say is perfectly valid for the white paper. The white paper produced no evidence for this proposition, which formed a significant part of the justification. My lady and my lords, what we do say is they certainly produced no evidence to justify the later statement that there's no significant development after the age of 18. And yet it would be necessary to establish that in order to justify the removal of the review from those sentenced at the age of 18. i.e., if there was no significant maturation after 18, then one could see that the bright line, drawing the bright line at 18 might make some sense. But if there is a significant maturation after the age of 18, and all the authorities and all the scientific evidence suggests that there is, then we submit that it cannot be right to exclude the review. If I can take you back, so that's the point we make at Roman 3. You determine the substantive punishment on the basis of the defendant's age at the date of sentencing. You should do it at the date of the offence, not the date of sentencing. At Roman 4, we make the point that the sentence of DHMP is founded on the rationale identified by Lord Bingham. That is, firstly, the lesser culpability of those who commit crimes as children, and secondly, their greater capacity for change. Neither of these factors alter because someone who commits an offence under the age of 18 attains the age of 18 before sentence. And to confer significance on the age of 18 at sentence and deny those sentenced after the 18th birthday the protections accorded exposes them to obvious arbitrariness. And you've got the example, the court I know has seen it, the consequence of those factors in an offender who have committed an offence of murder when, for instance, they were just 17, might be sentenced when they were still 17, whereas another offender of the same age who committed a very similar offence might reach his 18th birthday before the date of sentence. And it would be random that one reached the age of 18 before sentence. And furthermore, and this is Roman 5, we do say that there is an injustice of retrospectively removing the right of review, which has to be factored in to the overall. Now, my learned friend has asserted that the fact that a right is being removed is irrelevant. And he cites the case of Akbar in support of that. But can I just indicate that if one looks at Akbar, which is at tab 13 of the bundle of authorities, the key passage being at paragraph 73, so tab 13, paragraph 73, page 498. At the heart of this case, this is about the denial of open prison to certain prisoners who are liable to deportation, and my learned friend has underlined the passages at paragraph 61 to 66. And his submission there at paragraph 64, it was illegally irrelevant to the analysis at Article 14 whether or not Rule 718 modified a previously existing power. But if you look at the context, paragraph 73, the way in which they described what the issue was at the heart of this case is prisoner management and the balancing of scarce resources. Management of prisoners and offender is by operation of statute a matter for the Secretary of State. And the allocation of scarce or finite public resources calls for political judgment, and courts must tread with caution, affording appropriate weight in respect to the judgment formed by the executive or the legislature. It's got nothing to do, in our respectful submission, with the issue in this case, which is intimately concerned with the quantum of punishment and the removal of a right to seek a reduction of it by reference to time-honoured practice and the rationale of one's sentence. That's completely different from something about prisoner management and the balancing of scarce resources. So nothing from Akbar can assist the court, in our respectful submission, in determining this particular issue. So we say that there are very considerable damaging impacts to be justified, and those real impacts require justification, we would say, with careful scrutiny. At 4.4, we deal with the rare example of someone sentenced to detention during Her Majesty's pleasure at 40 for an offence committed when under 18. And we say the answer to that scenario, if one is needed, is that the sentencing judge, when dealing with an offender of, say, 40 years old, would then take account of all the changes that had taken place in him since his original offence as a child and any relevant maturation. I think my Lord Justice Lewis put that point to my learned friend, that would be, given that although his lesser culpability at the time of the offence justifies the sentence of DHMP, in practice, the likelihood of any realistic successful review based on unforeseen progress and maturation is very small. So if application were made for review later on, the Secretary of State might well legitimately refuse to refer the case for further review pursuant to the powers conferred by 27A5B. So, my Lords, what we do say is you cannot, by appeal to that rarefied and exceptional example, justify an approach that works real injustice to a significant number of people like the respondent, who are only denied the review they deserve as child offenders because their sentencing does not take place until their 18th birthday. And the Divisional Court's judgment at paragraph 59 referred to the fact that between 2015 and 2019, 7 offenders sentenced to detention during Her Majesty's pleasure after their 18th birthday applied successfully for a reduction. So taking against that, that's the impacts to be put in one side of the scale. The asserted objectives are threefold. Firstly, and we've headed it at 5.2, the need to equalise the position. The first justification put forward in the white paper and maintained in the pre-action protocol was the need to equalise the position between those who commit murder as children but who are not sentenced until they're over 18, with those given life sentences for murder committed over the age of 18. We say that that is a false conflation, as the Divisional Court rightly pointed out in paragraph 58. The need for such equalisation is clearly not a proper justification, given that age at the time of the offence is the crucial determinant of the appropriate punishment in accordance with long-standing principle. The second one is the assertion as to lesser capacity for change beyond their 18th birthday. My lady, I've dealt with that, but the point that's made about no significant development beyond the age of 18, we've made the point that whether there is an increase or a decrease in maturation after 18, it is a moot point. There's a debate on that. But the assertion, this is at Roman 2, of no significant further development after 18 is contrary to the position demonstrated by the fact and experience of minimum term reviews. And that point was made by the Divisional Court. Now, the appellant has made, it's at paragraph 49 of the appellant's skeleton, has made much criticism of the Divisional Court's assertion in one sentence at paragraph 50 that no evidence was provided for the proposition in the white paper about accelerated development and maturation. But that's an accurate criticism of the white paper. They're putting forward there the justification for a big change affecting fundamental rights. And they say, they make an assertion without any evidence, and indeed in the context where they've provided themselves evidence that the maturation process does continue. And it gets worse because they then, and this is at 5.6, sorry, 5.6, we deal with the question of whether any relevant maturation continues unabated. And Dr. Delmarge's evidence states that the rate of such relevant maturation...
I thought the court below had refused to admit the Delmarge evidence.
Yes, my lord.
So how can we look at it then without an appeal against the refusal to admit it?
Well, my lord, we have put in a request to the court to consider the court below stated it wasn't necessary because the sentencing decisions settle the point. My learned friend says the sentencing decisions don't settle the point. So that then Dr. Delmarge's evidence does become relevant.
Yes, but you've got to appeal against the refusal, haven't you? Or
Well,
you can't just put in evidence. If the court down below says this is not before the court, you put in the statements that were expressly refused, I noticed, at the end of the bundle. But I mean, if the court below says you can't have that evidence in, I don't see how we should then look at it.
well, my lord, if the basis, my lord, it's a short point, and the short point is if the basis for the court below saying we won't admit Dr. Delmarge is it wasn't necessary because it was already dealt with. My learned friend then says, well, actually, it's not founded, then it does become relevant. And we have specifically asked that the court should consider it. But my lord,
Just remind me where it's dealt with in the judgment.
Paragraph 24.
24.
The two witness statements dealt earlier with paragraph 34 is Delmarge.
yes, I'm grateful. Just one moment. Yes, formal admission of Dr. Delmarge's evidence is not necessary because it's already dealt with in Clark and others. Sorry. Yes, I see. I'm so sorry. Yes, yes. There was the Secretary of State's argument was it's not necessary because you've already got all the evidence you need through the sentencing decisions. So if they're now saying the sentencing decisions don't deal with the point, Dr. Delmarge does expressly deal with the point about the rate of maturation. And I can give the court just briefly the reference to that. Just give you the page where he deals with it.
Supplementary bundle.
Yes, it's in the supplementary bundle exhibited to Simon Crichton's affidavit. And
Was the divisional court wrong to say what it did? That one can look to Clark and Clark and/or a departmental memorandum.
well, my lady,
That's the MOJ memorandum, presumably.
my lady, can I put it like this? If the issue is the significant maturation after the age of 18, that is uncontroversial. It's established by the evidence of the MOJ's own memorandum. It's established by the cases of Peters and Clark. If the issue is, and this my learned friend makes much of in this appeal, is but the rate of maturation decelerates after 18, then Dr. Delmarge at page 290, paragraph 4.6 deals with that and says that's not correct.
How are we using this? Are we getting an expert opinion to tell a court of law that Parliament is just wrong?
No, my lord, it's the white paper that's wrong.
What's the white paper?
It's for them to justify. Their justification is look at the white paper. It gives all the justification you need. My lord, what Dr. Delmarge's evidence shows is that the unevidenced assertion in the white paper is incorrect. But my lord and my lady, the most important point, and the most important point we respectfully submit is that it would only be if they could uncontroversially assert that there is no significant maturation after 18, that it would make any difference in the end. And that's why it may not be necessary to look at Dr. Delmarge at all, because the crucial question is not whether it accelerates or decelerates, but whether significant maturation does take place. Because if it does, then to say the moment you reach the age of 18, there's no significant maturation, so we needn't look at you again, becomes irrational and unjustified. And that's our essential point. Sorry,
Mr. Fitzgerald, where in the memorandum is this dealt with? I'm sure you've taken us to it already, but
it's in the memorandum. They deal with the fact that there is evidence of maturation, but it's also in a policy statement.
30.
Yes, just give.
That's the passage to which you.
Yes.
So you really say paragraph 30 deals with the point sufficiently in any event.
Yes. A removal will be seen to go of a maturity continuing beyond the age of 18. Yes, my lord. Page 221. And my lord, there are other policy statements to similar effect which we've referred to.
So you don't really need Delmarge anyway.
Well, no, my lord. Can I just put it like this? My learned friend is saying, okay, there may be significant maturation afterwards, but it's not as significant as that before, therefore we can remove the right. We say that's bad, irrational reasoning. But if the court were to say, well, if it decelerates, if it's clear that it decelerates after 18, that could be a point, then we say it's important to point out that that itself is a highly controversial statement. And so we say it's not necessary to resolve this issue in order to find that there is no proper justification. But if it were considered necessary by the court, you have Dr. Delmarge's evidence. That's how we put it. So I'm sorry, my lord, I may not have answered.
Well, no, I mean, it was an expert opinion. There are rules of procedure. You've got the 2 witness statements at the end that you're expressly told not to put in. And it's a bit unhelpful to have things before this court that have been ruled out expressly on the grounds they're not relevant, or the expert opinion, which isn't relevant, and then to slip it in to the bundle. I can't see that that's a proper way to proceed.
Yes, well, my lord, we did refer to that alternative in our original pleadings. So, but my lord and my lady, it may not be necessary. I don't want to take up the court's time on Dr. Delmarge, because our central proposition is simply that the proposition that would be necessary for them to make out is that there is no significant maturation after 18, and they don't make that out, because that would be the only rational basis on which to say, well, we don't have, once you've had your 18th birthday, we don't need to look at you. I come then to the second justification, which we deal with at 5.7. And we say that there's no doubt that the reduction of distress to the victim's family was put forward as the main justification for the legislative changes in general, both in the White Paper and indeed in Parliament. But the principal concern was to reduce distress caused by repeated reviews. I know the court's now seen it. It's at page 328. Paragraph 328 of the White Paper, 329 and 330, talking about repeated reviews and the existence of the procedure which involved repeated reviews. There's no statement that any review at all would cause distress. It's all about, they find the existing system, which involves repeated reviews, to be distressing. And we say, and this is at 5.8, that concern at repeated reviews is not a justification for removing all reviews whatsoever. And that was a point made at paragraph 56 of the Divisional Court's judgment, where it's pointed out that the respondent in this case was not challenging the removal of second and further reviews. But to remove all reviews, even those at the halfway point, would be to remove an essential requirement of the sentence. Moreover, and this is at 5.9, the nature of the exercise of minimum tariff progress review, such as is required by the sentence of DHMP, does not of itself necessarily require input from the victims' families. Now, that's a point made in the Divisional Court, paragraphs 55 to 56, citing the judgment of the case of Cunliffe, which I think, my lady, we handed up this morning, the Cunliffe case. And so, can I just take you first to Cunliffe and then to the Divisional Court on this issue? So, Cunliffe is would it be sufficient if I just took you to the key paragraphs, my lady? Because
Yes.
the fact that it was a judicial review because a victim impact statement had been put before the decision-making judge, and it was held that it was unfair because the prisoner hadn't seen it. But in the course of the judgment, the issue arose what the role of a victim personal statement was in this exercise, and at paragraph 39, of the judgment of Lord Justice Bean, he said, victim personal statements are now an established feature of sentencing in the criminal courts. As Mr. Stanbury rightly submitted, in some cases they are of great importance. They have also become part of the material considered by the parole board when deciding whether, and if so, with what restrictions, an offender can safely be released into the community. A statement made at the stage of sentencing must be served in good time on the defendant's solicitor, etc. And then it deals with the question in the parole board, where, of course, the victim's family have a right to be heard, and the special provisions for their statements to be put before the parole board and withheld in certain circumstances. But this is the important point at paragraph 40. I do not understand why it is thought appropriate to invite the submission of an updated victim personal statement when a judge is being asked to consider a review of a minimum term on the grounds that the detainee has made exceptional progress in prison. The judge is not being asked to express a view about the correctness of the original sentence, nor on the degree of risk which the detainee would present if released. If it is indeed possible for a judge conducting a periodic review of the tariff case to be asked to reduce it on the grounds of any matter that calls into question the basis of the trial judge's decision, then different considerations might apply. But that is not the present case. And then if we look at the judgment of this is Justice Cobb, as she then was, I agree, this is paragraph 49, in relation to procedures adopted by Mr. Justice Mitting, it is clear that the victim personal statement was irrelevant to the issue of exceptional or unforeseen progress before him.
Well,
So,
I think it's quite difficult to, I mean, one also has to look and see what's said in paragraph 6, doesn't one? Where so one sense it may be obvious that if somebody is in circumstances such as in relation to this dreadful crime, is applying to reduce their tariff, that you can see what's said, I'm going to read it out, but what's said in the passage which is cited from the statement that was under consideration.
yes.
Isn't that the point? It's the distress point that's being identified rather than the materiality to the decision.
Yes, well, my lady, I accept that, but perhaps this is important that it may, if a victim impact statement itself is not necessary, we of course accept that being informed that there will be this review is of itself distressing. We accept that is the case. But if it's not necessary to require or accept or invite the victim impact statement, then what we're dealing with is not repeated reviews, obviously, but the fact that one is notified that there will be a review, at a single review at the halfway point. And we say that then the existence of that has it's quite right to say, as the court said, effect of a single review of them will be modest.
The difficulty that I've got with that is you're almost inviting us to draw up a system which balance things out and say, well, we won't trouble the family because they'll be upset and there's no need because they're not going to have to say anything. Well, firstly, other people may disagree with that. But secondly, this is a question for Parliament. They do have a system where the family are informed. And I can well understand why Parliament might say the family ought to be informed.
Well, informed, yes.
Parliament is then, or one view, Parliament might be saying, well, look at the distress that's being caused. How much change is that going to make in the over 18s who've already had a sentence based on seriousness and so on? If it was that kind of exercise, there would be a different reaction from a court as opposed to a situation where you come to us and ask us as an advisory body, how would you set up the system? It's quite a different exercise.
Well, my lord, in answer to that, my respectful submission is, if one goes through a proportionality exercise in relation to that, it is disproportionate to remove an important right. Let's take it in stages. To take this right away from those who've enjoyed it and were expecting to have a review on the basis that a single review will cause distress. It's just, and we do invite the court to make that finding as the divisional court did. But secondly, and that's as it were moving forward, we invite the court to find that it's disproportionate to find that a single review it would be so distressing, given the nature of the input that would be required, that it would be proportionate to remove that review. I don't know, that basically is the submission that the divisional court were correct to say the effect of a single review would be modest, and then and we make the point that in any event this is not an area. If it were the case that a family of the deceased could say, well, once sentencing is over, that's it. We'll draw a line under it, we'll never have to hear from it again. But the moment there's a parole board review, a family is repeatedly contacted at that stage. This is, as it were, the cost of having a system where we value the input of the deceased family, that they will be notified, that they will have input. And because it's regarded as appropriate that they should, at that stage, they will be invited to put forward statements to the parole board. That's simply provided for. So if you look at that overall context, they do have an input, and a necessary input, at the sentencing stage. They do have an input, a necessary input at the parole board stage. They have a limited input at this stage, and there would just under the be a single review, because we're not seeking to strike down anything more than that, the removal of that single review. Then we do submit that it's disproportionate, and that is a judgment which we submit the court can make, and indeed we invite the court to make. That if you look at the impact, the removal of a vested right that did exist, the discrimination that it involves, and you look at the minimal amelioration of the position by taking it away from just this small subgroup on no rational basis, that's to say just because they happen to be sentenced after 18, then we do say this is something which the court can say it is disproportionate, and SC and indeed all the cases make clear that it's perfectly legitimate for the court to look with careful scrutiny as to whether it's really necessary and appropriate. And we just make the one further point that if the court finds, if the court finds this is discrimination, then and indeed we suggest, and it's discrimination on the basis of the date of sentencing, what is the relationship between the removal of that single review and the reduction of distress? All one can say is, well, those particular individuals who have been sentenced after 18 will not have a review, and to that extent the, as it were, quantum of distress will be reduced somewhat, but only somewhat. And we say, as against that, you have all the points that we make in relation to the massive impact this will have on the individual's rehabilitation and expectations, and we would respectfully submit rights pursuant to the original sentence. So that it is a question of overall proportionality, and we submit that there's no evidence that Parliament considered, well, remove repeated reviews rather than all reviews. There's no evidence that Parliament considered the question of what about those who are in the pipeline who have gone along with the basis that they would have a review, and there's no evidence that Parliament considered the particular case of those who were already actually in the criminal justice system under the age of 18, and that therefore it was merely because the criminal justice system took some time that they lost their right to a review. I think that those are the submissions in relation to Article 14. Then in relation to Article 5, we simply adopt the reasoning of the Divisional Court. We dealt with this at Part 7, and we say that as the Divisional Court observed, and this is if we look at paragraphs 59 to 60 of the Divisional Court's judgment. So they turn to Article 5 at paragraph 59, page 102. Dealing first of Article 5, we've determined that Section 27A did not change the essential nature of a sentence of DHMP. An inherent element of the sentence is the requirement of continuing review, as set out in Venables and Smith. It is in that context the question of arbitrary detention falls to be considered. In our view, the removal of any possibility of a reduction of the minimum term via a review does generate a risk of arbitrary detention sufficient to engage the protection of Article 5. Mr. Watson's argument that detention cannot be arbitrary whilst the minimum term is ongoing fails to engage with the particular review and reduction element of a sentence of DHMP. Mr. Fitzgerald was correct to distinguish sentence of DHMP from an ordinary sentence to which parole provisions apply. The requirement of a continuing review inherent in a sentence of DHMP is unique. Whilst the established system prior to the 2022 Act involved review only at or after the halfway point of the minimum term, any offender serving a sentence of DHMP has their progress regularly examined and recorded by the prison authorities so that on application for review, all relevant material can readily be assembled. We repeat what was said in Smith, namely, as a child murderer grows into maturity, a more reliable judgment may be made, perhaps of what punishment he deserves and certainly of what period of detention will best promote his rehabilitation. This is why a distinction must be drawn between a sentence of DHMP and other sentences as discussed in Morgan, removing any possibility of exercising a more reliable judgment so as to reduce the minimum term will inevitably result in a number of offenders serving longer than lawfully they should. That is established by the evidence which within the memorandum of 16th of October. Between 2015 and 2019, around 7 offenders applied successfully for reduction of their minimum term. Those offenders would have remained subject to a minimum term longer than necessary, best to promote rehabilitation. In the context of an offender serving a sentence for a crime committed when the offender was under 18, that amounts to arbitrary detention. In the course of oral submissions, Mr. Watson submitted the manner in which reviews of minimum terms imposed on young offenders had been administered prior to 2021 and then was more generous than required by Article 5. This was a reflection of what was said in the memorandum, and the policy has been in force thus far has been more generous than what is legally required by case law. We do not agree with that statement. There is nothing in Venables or Smith which would support the proposition. We were regarded as remarkable if successive Secretaries of State since 2006 had been referring for review offenders with no legal right to any review of the minimum term. Follows, we conclude that Article 27A1 and 27A11 is incompatible with Article 5, and we shall make a declaration.
If that's right, the restriction for the under 18s to reviews only up until they're 18 must also be a breach of Article 5. If the sentence is to carry with it a right of review to ensure that it's always the right to appropriate term and things can change, to say you can only have a review or a further review up to 18 is also Article 5
well,
non-compliant.
My Lord, everybody under this procedure, apart from us, the excluded group, everybody gets one review. All the others get one review.
That's incompatible with the nature of the sentence you've just told us. It's there to ensure continuing review, to make sure that you're fitting the sentence with the offender. And you've told us that between 18 and 25, there's lots of maturation.
Yes.
So to say that somebody who's under 18 and has a sentence of DHMP and is continuing to mature after 18 can't have another review is a breach of Article 5.
Well, that person's, I mean, it's rather hard to envisage that person because they've already had 2 reviews before the age of 18.
So they'll might only have had one depending on the age and the length of the minimum term.
Well, in that case, so everybody gets one review at the halfway point, my lord.
Yeah.
So the important point is, simply because that's all we've challenged in this case. But
No, I'm just testing it. The
yeah,
logic
no, I
must-
understand.
The logic must be if you've got to have continuous review to match the sentence with the offender. Certainly, if you stop continuous reviews after 18, I know they've got one, but say they've had one at 19 or 20, depending on the terms of the sentence, not to have it afterwards.
So
Would be a
is-
breach of Article 5.
well, my lord, that's not this case. Obviously, I'm not sure, but I accept your lordship's point about the challenge. The concept is that everybody, according to the Secretary of State is that everybody will have one review, and any subsequent review will have to be under the age of 18.
But that's, I don't really care what the Secretary
No.
does. It's the Act you've been telling us. The 1908 Act has with it a right of continuous review. And presumably it's a breach of Article 7 for those under 18-year-olds who can't have more than one review now. Their sentence is harsher than it was before.
Yes. Yes. Well, my lord, what we respectfully submit is that the right of review is that the sentence should be capable of reduction, should be susceptible to reduction. Let's say the best way to encapsulate the concept now is that it's a reducible penalty.
Yes, I follow that, but I mean, the same thought had been occurring to me, which is how you tie in the scope of the challenge, which is made on one point here, which is the effect on those who pass the age of 18 by the time of sentence, with the failure to challenge, if you like, the renewal, the opportunity to renew or to have a further challenge after 2 years or whatever it is, because you say that the maturation process continues after the age of 18. You might have somebody who, I'm trying to think, I can't quite do the maths in my head, but you might have somebody who is 18 at the time of sentence and would otherwise have the opportunity not only to have a review at the halfway stage, but also further reviews later on.
Yes.
And what is the basis for saying that the removal of that in itself, for the same reasons that you advance in the support of this challenge, wouldn't also apply there?
Well,
Is it's simply chronological?
yeah. Well, my lady, what we say is, you are at least entitled.
Yeah.
You are at least entitled to put your case for the reducibility of your penalty at the halfway point of your sentence. So, if I mean, taking your ladyship's example, someone who's 17 and their tariff is 15 years, they have the opportunity to put their case when they're 26. Sorry, no, 23 for review, and they can put their case then. I mean, it may not be that they're heard immediately, but they are entitled to say, I have developed and matured, and therefore the tariff should be reduced.
Yes, but if one goes back, then one goes back to look at those who are under the age of 18 when they're sentenced. On this scenario, they are, on the legislation as it now stands, they lose the right to further reviews after they pass the age of 18.
It precludes that.
30-year-old who gets an 8-year sentence, he's 17 at the time of halfway through and he gets one review. He can't get a second review because he's got to wait for 2 years. So you get to 19 and he's being arbitrarily detained and has been throughout on your case.
Yes.
And it's retrospective to take away that chance that he had. He might not have matured enough by 19, give him another 2 years, he might
Well,
have.
My lord, this, I mean, it's perfectly right to look at all the implications, but obviously we've thought in this challenge what the glaring injustice is to this particular applicant. I'm not saying the court shouldn't look. Obviously and the divisional court said this, they said, we're not going to deal with the question of whether there's a right to a further review, but
With Article 5, we have to, because if the finding that you have been unlawfully detained, contrary to Article 5, if that is the basis of it, we have to say why. And the reason why, as I understand it, is you say that it's inherent in the sentence, coupled with the fact that there's the opportunity for maturity. But if that is the basis, then the consequence of the finding, and if that's the finding, we just have to live with it, is that lots of other people may also be arbitrarily detained and detained in breach of Article 7.
Well,
you can't limit it to the fact that Mr. Quaye.
no, I accept that, my lord, but what we say is at the very least, it is inherent in the sentence that firstly, that your tariff is a reducible tariff. And secondly, that you should have you should have the right, at some point in your sentence, it could be the half or you could postpone it, but you should have the right at some point in your sentence to put the case that I have matured, developed to the point where I'm entitled to a reduction. And that is what Lord Bingham says in A. It's been the policy, and people have made those applications over the last 2 decades. But Lord, the question is, does Article 5 require this? And we say that Article 5 at least requires that in respect of this reducible penalty, you get an opportunity to put your case for reduction. And my lord, so can I put it this way? If you are denied all opportunity to put your case for reduction, then that makes the detention after the halfway point arbitrary. That's how
But where do you get the basis for that? It's the denial of all opportunity.
Well, my lord, because that at least is arbitrary. Whether there's a further arbitrariness is not the way we don't have to argue that, my lord. We don't invite the court to find that. We just say that if you remove all opportunity to put the case that this reducible penalty should be reduced, then the detention in the absence of that opportunity to put that case is arbitrary.
Well, and we also have to consider the language of paragraph 59, quite broad in terms. Paragraph 59 of the judgment
yes.
of the divisional court,
Yes.
which is quite broad in terms.
Well, in our view, the removal of any possibility of so in our view, the removal of any possibility of a reduction of the minimum term via review does generate a risk. So that is our point. The removal of any possibility of a reduction of the minimum term via a review does generate a risk of arbitrary detention sufficient to engage the protection. My lady, we would stand by that sentence because it's the removal of any possibility. And then they repeat it again, removing any possibility.
Yes, I mean, only have in mind the various passages where it says an inherent element of that sentence is the requirement of continuing review as set out in Venables and Smith. Requirement of a continuing review, etc., is unique. Those are the passages I have in mind.
My lady, I appreciate that, and obviously throughout the history of this, I mean, one could say that the tariff itself, I mean, the argument was put in Venables, and indeed only in Venables, that actually the tariff itself was inconsistent with continuing review. Well, that was ruled against in Venables. They said, no, it's okay. You can.
That was a Secretary of State made tariffs. We've got Parliament now has changed it as well, don't forget. The argument in Venables was that a policy of the Secretary of State couldn't contradict the provisions of a 1908 Act of Parliament.
Yes.
But now you've got a 2000 and now a 2020 Act. It's a completely different comparison.
My lord, it is, except that you've still got the fact that this sentence, which had its established case law about what it meant when it was reenacted, has been reenacted time and time again against the background of the definition of that sentence in Venables and in Smith. And one has to attach some importance to the fact that Parliament, knowing full well how that sentence has been interpreted and what it was interpreted to mean, has repeatedly said, this will be the same. So before our client was sentenced in 2015, detention during Her Majesty's pleasure was reenacted.
And said to be a life sentence.
Well, only for the purposes of calculating certain matters. It wasn't said. It wasn't. No one has ever suggested it's the equivalent of a life sentence. Indeed, that argument was expressly
They operate as if it's the equivalent of.
for certain.
the minimum
Yes,
term.
for certain purposes, my lord. Yes, I mean that's all that means. And my lord, I've made the point that it's when Section 82A, the 2000 Act, was introduced. It was clearly introduced against the background of the Venables decision, but there was no interpreting it, and there was no suggestion that, as it were, they were going to alter that interpretation. And indeed, the interpretation held good after the 2000 Act, such that the tariffs fixed under the 2000 Act were regarded as reducible to the next.
I expressed interest a number of times as to how that actually happened. I mean,
well, my lord, I think at one stage there was the Secretary of State was posing the question of whether they could depart from the procedure, and then, as it were, capitulated when the matter went for judicial review. So that.
but it looks as if, from what we've seen, that the judge isn't sitting as a judge. It looks as if it's a recommendation, because Mr. Justice Mitting appears to have been judicially reviewed, and he couldn't have if he was sitting as a High Court judge.
No, that's right.
So it's a peculiar animal, this, which I can hardly wait for tomorrow when we get Mr. Watson to tell us the answer.
About the record. Well, I think we've so far as we know, the answer is that a recommendation was made and it was given effect to, and that
Nobody's going to challenge it except possibly the victim's family. Yes. Anyway, that's another thing. Yeah.
Yes, exactly. Well, my name, those are our points on Article 5. We don't accept that that this exercise of reduction, conducted in accordance with the principles in Smith, is an exercise of early release. It is a question: should this sentence be reduced in the light of the person's progress? And if it is reduced, then that becomes the sentence. And certainly, that's when you get parole, your sentence isn't recalibrated, isn't reduced. You're just released early from the sentence that was imposed. When you get remission, your sentence isn't reduced. You're simply released with remission of your sentence. But this is a unique exercise of actually reducing the sentence. And so to just characterize this as early release, or indeed an exercise in the administration of the sentence, is incorrect. The sentence can be reduced so that you have a new sentence.
Are you going to deal at some point with the Supreme Court's decision in Brown at paragraph 39?
Obliged, my lord, I think I better.
Page
yes.
432.
Yes, thank you.
Authorities fund.
Yes, so
On this point, I think, final sentence or two of paragraph 39 on 332.
yes, well, I have that marked, yes. European Court, on the other hand, regards the issue of lawfulness arising only after the tariff or punishment part of an IPP sentence has expired, where earlier measures to encourage the prisoner will form part of the relevant zone. Yes, well, that's to deal with a question of tariff in an IPP sentence. So, my lord, the position is, where you have a tariff for discretionary life sentence, or a tariff for mandatory life sentence, or indeed for an IPP, that tariff is fixed and immutable. It can't be increased, it can't be decreased.
Yes.
This is a unique sentence in the sense that it is, and I accept my lord's amendment, it's a reducible sentence. It's a reducible sentence. If our
Until reduced, it's lawful.
Sorry?
Until reduced, it's lawful.
well, to remove the question that arises is, at the stage where the person has a case for reduction, and he's not allowed to put it, does that lead to arbitrariness of detention?
Because it's lawful. He's been sentenced to detention at His Majesty's pleasure. He's not entitled to get out until His Majesty's pleasure changes and he's released. He will know he'll get out at a minimum stage because there's now a tariff subject, of course, to the parole board. And so long as he's in there under those provisions, he can't bring a claim for false imprisonment.
No, my lord, but I think the concept of arbitrariness under Article 5 is somewhat wider.
No, I'm just giving you an example. I'm
No.
not saying it's the same. I'm just showing you that
Yes.
it's perfectly lawful to
Well,
keep him there.
Okay. The this is where we get
It
into
might never be reduced. It might never be reduced.
no, but if you have, let's assume the extreme case, an overwhelming case for reduction, and that case is not heard, you certainly got a violation of Article 5.4, but we would say you have a violation of Article 5 because you suffer the potential for arbitrary detention.
The detention is arbitrary. You've been sentenced to 10 years because you murdered somebody in terrible circumstances. If you show that you really changed, you might actually, on the part of the state, be given the opportunity to get out earlier. But it doesn't mean that the detention for the 10 years for the awful murder you've committed is arbitrary or unlawful.
But at the point where after 8 years of let's say the halfway point, after 8 years in your halfway point is 10, where you say I have an overwhelming case on the criteria to be
You've
released.
shown mercy or clemency or
Well,
whatever you want to
but-
call it because you've changed so much.
Well, I would respectfully submit it isn't mercy or clemency. It is the reducibility in accordance with the principles of exceptional progress. But my lord, and my lady, that's how I respectfully put it. That it is a different exercise. The difference between the tariff in all other indefinite sentences, that's to say mandatory life, discretionary life, IPP, and this is that this is a uniquely reducible sentence. If you convert the reducible sentence into an irreducible sentence, you are exposing to arbitrary detention. That is my submission. My lady, that does actually lead on to the point about Article 7,
Yes.
which is the final point we made, and that is we've dealt with it very briefly, but in the speaking note. But again, there is the question then whether this is simply about the administration of the sentence, or whether it is an actual change in the sentence. And Article 7 raises different issues. So again, the existential situation, you have been sentenced in 2015 to a reducible sentence. That has now been turned into an irreducible sentence. We say that that is a harshening of the penalty that breaches Article 7. And we put this at Part 8, page 17. So we say further in the alternative, in this particular case, the respondent relies on the very fact that they claim the appellant claims that the sentence has been amended or redefined so as to exclude the right to review or reduction, which was an intrinsic part of the sentence of the HMP. And on any view, there's been such an alteration in the operation of the sentence as to amount to a denial of its fundamental essence. In those circumstances, the case law recognises that where the nature of the punishment is, I quote, amended or redefined retrospectively at a later date, this gives rise to a violation of Article 7. And in that respect, we dealt with this in our detail in our skeleton, paragraphs 53 to 54. But can I just show you the key cases that deal with the issue? So Del Rio Prada, my learned friend has already taken you to, in tab 9 of the authorities. At paragraph 109. And it's just to show this crucial test. So at paragraph 109, page 390, regard being had to the foregoing and to Spanish law in general, the court considers that the recourse in the present case to the new approach to the application of remissions of sentence for work done in detention introduced by the Parrott Doctrine cannot be regarded as a measure relating solely to the execution of the penalty imposed on the applicant, as the government have argued. This measure taken by the court that convicted the applicant also led to the redefinition of the scope of the penalty imposed. As a result of the Parrott Doctrine, the maximum term of 30 years imprisonment ceased to be an independent sentence to which remission of sentences for work done in detention were applied, and instead became a 30-year sentence to which no such remissions would effectively be applied. The measure in issue accordingly falls within the scope of the last sentence of Article 7.1. So the ratio there is, if you remove the fact that the sentence was one to which remission of sentence applied, you are changing the nature of the sentence. And in our case, what has happened is a reducible penalty has been turned into an irreducible penalty for those who are over 18 at the time of sentence.
I mean, I follow that argument. I did look back to see what the judge had said at the time of sentence. One looks at paragraph 89. Obviously, yes. I mean, it's interesting to see. May have no more significance than that. It was said that they would be detained for a minimum term of 15 years. That means you'll be held in secure custody for at least 15 years. It may be a lot longer. You will not be released unless and until the parole board is satisfied. I mean, I suppose you would say that that form of words was inapt in the circumstances.
Yes, the ghost hovering over that is the judgment in Smith, and that at that point it certainly was the case that was a reducible penalty. And so what the judge was doing was defining the outer limits of punitive detention, but it was always susceptible to reduction in the light of progress or reconsideration. Always.
Yes, back to
But
Article 7.
I think, as my Lord has pointed out, the difficulty is the sentence remains constant. But superimposed on the sentence has been the tariff structure, the way in which the courts in both Venables and Smith is to say, well, okay, you can have your tariff, the tariff must be reducible. And And Lord Bingham said it doesn't matter whether the person fixing the tariff is a judge or the Secretary of State, that remains the position. So that's Del Rio Prada. Khan interpreting Del Rio Prada is the next one. Where the court stated the amendment by the legislature that occasioned a redefinition would constitute a violation. That's in paragraph 105 of Khan, which is Authorities tab 12, and paragraph 105, my lady, we have, yes, at page 483, top of page 483, in the present case, changes wrought by the 2020, changes in the arrangement for early release, they were not changes to the sentence imposed by the sentencing judge. In the absence of a fundamental change of the sort described in Del Rio Prada, a redefinition of the penalty itself, the principle is clear. An amendment by the legislative arrangements for early release raised no issue. So that again, the two different situations that are being put as the key test is this a redefinition of the penalty itself? Or is it simply a change in the way that early release arrangements are made? And we say this is clearly a change in the penalty itself from a reducible penalty to an irreducible penalty. And then if we go finally to the case of Kopinski, in Kopinski, we've got Kopinski at Authorities tab 17. And in Kopinski, the change from a reducible life sentence to an irreducible life sentence was held to go beyond mere measures of enforcement and change the scope of the applicant's penalty. If I can just show the court that briefly, tab 17, the facts are at paragraphs 44 and 49. So what had happened was that there was a penalty imposed in Hungary. The applicant so 44 complained that although the Hungarian courts, this is page 656 at para 44, the applicant complained that although the Hungarian courts had sentenced him to a reducible life sentence, the Ukrainian courts had converted that sentence into what had turned out to be a de facto irreducible life sentence, amounting to a heavier penalty in violation of Article 7 of the Convention, which reads as follows, and then it's set out. I won't read it. The government argued, this is at paragraph 45, that in bringing the judgment of the Hungarian court into line with Ukrainian legislation, the Regional Court of Appeal's decision had not imposed a penalty on the applicant. It referred to the court's case law, which stated that transfer decisions in either the sentencing or the amendment did not fall within the ambit of Article 7. And if we now look at paragraph 49, 46, you see what the applicant contended. The conversion of his reducible life sentence to a de facto irreducible life sentence had affected the scope of the penalty and led to a less favourable penalty being imposed on him. He maintained that Hungarian law distinguished between reducible and irreducible life sentences. And given that the Hungarian authorities had imposed a reducible life sentence on him, the Ukrainian authorities worsened his situation by replacing it with what had turned out to be an irreducible life sentence. Paragraph 49, after citing cases about the transfer, however, the court has also acknowledged that in practice the distinction between a measure that constitutes a penalty and a measure that concerns the execution or enforcement of the penalty may not always be clear-cut. The concept of penalty in Article 7 is like the notion of civil rights and obligations and criminal charges, autonomous in scope. The wording of the second sentence of Article 7.1 indicates the starting point in any assessment of the existence of a penalty is whether the measure in question is imposed following conviction for a criminal offence. Other factors that may be taken into account as relevant in this connection are the nature and purpose of the measure, its characterisation under national law, procedures involved in the making and implementation, and its severity. And then there's this long citation from Del Rio Prada. But if I could take you now to paragraph 51 52, the court notes that unlike the cases in which a change in the regime for release on parole was found to belong exclusively in the domain of the execution of a sentence, in the present case, the applicant's transfer, and in particular the manner in which his penalty was converted, ultimately amounted to a change from a regime allowing release to no availability of parole at all. As the court has found, the applicant's sentence imposed as a result of the conversion is irreducible under Ukrainian law. Whilst the principal difference between the present case and the previous ones concerning transfer, those cases concern the terms for granting parole in the state to which the prisoner was transferred, etc. But 52, in the court's opinion.
Yes, hold on. I mean, there is no availability of parole at all under the Ukraine law. In the last part of 51, Hungary had two different sentences, one where you could have parole and one where you couldn't have parole. It was like our whole life orders. And they had deliberately sentenced him not to the whole life order equivalent, but to the one with parole. But Hungarian law said, no, you're not going to have parole. You'll be there forever.
You mean Ukrainian law?
Ukrainian law, yeah.
Yes. Yes, well, my lord, I accept that, but if can I just take the point in the 52 in the court's opinion, irreducible and reducible life sentence differ as to their scope. The difference has been significant enough for the court to find the former incompatible with the requirements of the convention. So I mean, they're both called life sentences, but so if you look at the tariff in this case, the relevant part, the minimum term imposed was reducible in accordance with the principles in the Venables and Smith case. It then became irreducible as a result of a legislative change introduced halfway through his sentence. And you can see at paragraph 56, the court therefore concludes that by converting the applicant's original reducible life sentence, the one that is irreducible under Ukrainian law, the domestic courts in the particular circumstance of the present case went beyond mere measures of enforcement and changed the scope of the applicant's penalty. Article 7 is therefore applicable in the present case. Well, our respectful submission is that if you apply that criterion to the facts of this case, there has been a legislative conversion of a reducible minimum term to an irreducible minimum term. And that violates Article 7. My learned friends rely on the case of Morgan, but if we look again at that at term 16, there's a key passage where Lord Stevens encapsulates a test that has to be applied at page 638, para 104, 638F. Two propositions follow from the above. This is after an analysis of Del Rio Prada. One, first, where a measure relates to the execution or enforcement of a penalty, it does not fall within the concept of law. In Article 7.1 of the ECHR, the requirement of foreseeability does not apply. Second, wherever a measure relates to a change in the penalty imposed, and as such falls within Article 7.1, any such change falls within the concept of law and is subject to the qualitative requirements that follow, including foreseeability. And so we say this is a change in the penalty, and in fact, it was not foreseeable that the penalty would be changed. Indeed, it was only at the very last moment before he came to enjoy the opportunity for a review which would reduce his penalty, that the legislature intervened and turned his penalty from a reducible one into an irreducible one. And the very language that my learned friend uses, the redefinition of the sentence, the amendment of the sentence in his skeleton, I think the amendment's at paragraph 43, that shows that the test formulated in those cases and encapsulated by Lord Stevens is one which is satisfied. This is an Article 7.1 violation. There's no doubt that he is now being treated more harshly than was envisaged at the time of the original penalty. Therefore, there's no doubt also that this is not simply about the execution for the sentence. The sentence is the term, because there is authority, and we've given it to you, that the relevant part of a sentence is a separate sentence which you can appeal. The minimum term, you can appeal the minimum term. So it's no answer to say the sentence is and remains detention during Her Majesty's pleasure. There is a severable, complete part of the sentence which one could have appealed, which is the relevant part, the minimum term. That is itself a sentence. That minimum term, which is itself a sentence within a sentence, has been converted from...
Well, legislation requires the minimum term to be set at the time the sentence is passed.
Yes. But
I'm not sure it helps to describe it as a severable part of it. Is it?
Well, my lady, it may not matter. The point is the somewhat, if I can call it, facile answer. Well, your sentence hasn't been increased because you're still subject to detention during Her Majesty's pleasure. Ignores the fact that the term is itself a penalty, and the conversion of that penalty, which is itself appealable as a separate entity.
The minimum term consistent with the seriousness of your offence.
Yes.
You should be serving in prison, and should you show an exceptional progress thereafter, they may reduce not so much the penalty as say you should be rewarded for that, and the way we do it is by reducing the minimum term, not because the minimum term was wrong, but because you deserve.
But that's the case with all. I mean, it's the case with the irreducible life sentence of the other cases. What basically has changed is that the possibility of getting it reduced has been removed. And it's been turned, I mean, that's the very language of Kopinski, is from a reducible into an irreducible penalty. It doesn't matter what the basis of your application for reduction would be. It's not an exercise of mercy, it's an exercise of
the sentence, the penalty is detention at His Majesty's pleasure, which can continue for life. And the minimum term is the minimum term, and in addition, you can show exceptional progress, or you used to be able to show exceptional progress, and the minimum term would be reduced.
Well,
so that part of the penalty, which is the minimum term, but
so we respectfully submit that the minimum term is a penalty which, if converted or redefined so that it becomes irreducible when it was reducible, comes within the terms of Article 7.
And how does that fit with the under 18-year-olds who've lost more than one review? It's not because they've got one review that stops it being irreducible, is it?
Well, it is reducible, but it's reducible on a more limited way, but it is reducible, yes.
That's enough to stop that being Article 7 for the other people, the under 18s then?
Well, my lord, it's certainly a relevant distinction, and we can submit here that the penalty has changed from a reducible into an irreducible penalty. Whether they could or not is certainly debatable, because...
Could you claim the reduction to not having... You used to be able to have more than one review. You could go back more than once.
Yeah.
So why isn't that then a heavier penalty?
Well, because it's still... Because it remains reducible. So, for example, the person could say, I will save up my review, as it were. I'm entitled to review at least at the halfway time, but I'll save it up until 2/3 if they're making progress. But they do have the opportunity to have their sentence reduced from the halfway point onwards. They have that opportunity. But my lord, to say where does this end is never a really good answer to the question. If you do this, does it violate Article 7?
No, I was thinking the other way. I think our declaration, if you're right, should be much more dramatic. It should be, you can't do this at all by restricting the amount of the reviews.
Well, my lord, the number of reviews may be, I mean, one, we don't challenge them in this case, but two, may be debatable. How many? But the fact that there should be some review, some point, you may be able to elect when if some people save it up, as it were, and say, well, I won't have it at the halfway point, but I could have had it at the halfway point, I'll have it later. But if you can't at some point put the case that in the light of your progress in custody after the halfway point, your sentence should be reduced from reduced from the original sentence to a lesser term, then we say the very violation identified in Kopinski and the conversion identified in Del Rio Prado, redefinition of the scope of the penalty, that prohibition is offended against, and we say it's distinguishable from the Brown case and distinguishable from the Ministry of Justice case, where one could say this is just a change in the enforcement of the sentence. Okay.
Fitzgerald.
I'm so sorry, my lady, I have a very
Yes, I understand that.
but a number of I don't know whether you
Yes, I think probably now is a convenient moment.
give me a moment.
No, it's 4:20.
Yeah.
So I think it's probably a convenient moment for us to rise and gives Ms Woodrow an opportunity to have a discussion with you about it. All right, thank you very much. We'll rise and sit at 10:30 tomorrow. Thank you very much.
All rise if able.